Okay, folks, let's get started. We're going to be talking here about the legality principle. This is the language that we use in the criminal law to describe the origins of this law, the institutional origins. Where does it come from? And the answer that we give in the United States is that the criminal law comes from legislative bodies, whether it be the state legislature or very often a city council that passes an ordinance, or even the US Congress that passes criminal statutes from time to time. So criminal law today in the United States is a heavily statutory area of law. It comes from legislatures, but it wasn't always this way. American criminal law in its earliest forms was really a creation of English judges, guys like this guy. And they were guys at that point. We call this the common law. That is, the judges created this law themselves without reference to pronouncements by the legislature. They created it incrementally. They were reacting to the facts of disputes and events that had already happened. And then ultimately that English common law of crimes came over to the United States, and American judges and juries put their own stamp on the criminal law. But again, it was judges in the judicial system that were creating the boundaries of criminal law for the earliest part of our history. Now, legislatures in the various states started to assert their control over criminal law in the early 19th century, or early 1800s, and the process was essentially complete by the middle of the 20th century. So that at that point, everybody agrees there is no common law of crimes. Typically, the legislature takes the lead. There are some little exceptions here and there, but it's basically a legislative area. Why did that happen? Why did we shift away from judges to legislatures in control? And why did this happen with the criminal law, but not so much for torts or for contracts or for property, where judges still have a very vigorous law creation function? Two big reasons. Reason number one, legislatures are thought to be more democratic and more responsive to the priorities of people than judges are. Now, you can argue with that, maybe when in a world where there are elected judges, as it happens in a lot of the states, maybe the judges are no less responsive. But generally speaking, we say legislatures are more responsive, more democratic, and that's especially important in the criminal law, which is thought to be the embodiment of public morality as it's translated into law. This is where our public values are most clearly expressed. Our public disapproval of certain conduct is most clearly expressed. So it's important that a democratic institution, the legislature, handle that job for us. Now, the second reason why we have favored the legislature, given them the leading role in creating the criminal law, is that legislation is thought to give better notice to the public. That is, when you got legislation, you declare it in general terms and prospectively. You write it down and say, going forward, this is what's going to happen. You can look in one statutory code and find the relevant rule rather than trying to piece together the multiple implications of lots of different cases as they relate to one another. Again, this may be overstated as a difference between legislation and judicially made law, but the general idea is one that has gotten a lot of traction over the years, that legislation is a better way to give notice to the public. It looks forward. We have to declare ourselves ahead of time. So a judge in the common law setting can look backwards and say, that thing yesterday that happened, that was a tort, or that thing that happened yesterday, that was a breach of a contract, and we're refining the principle for the first time. You can't look backward in crimes. You have to look forward and say, we declare from here going forward that this kind of conduct will be punished as a crime. This is thought to be especially important with crimes because what's at stake is liberty, or sometimes even life. The punishments are so severe that we think it's very important to give the best notice available, and that's thought to be from the legislature. The slogan, "No common law of crimes," means that judges are reluctant to create new crimes, even when they're faced with a person who clearly did something wrong, but it's not covered under any of the existing crimes. Under that same slogan, no common law of crimes, judges also typically refuse to even keep an old common law crime if the legislature has done nothing to embrace it. Now, the legislature does sometimes embrace old common law crimes, but if they've done nothing, the judges under this doctrine are willing to abandon old crimes. An example of that shows up in State versus Palandrano. The grand jury here indicted Marion Palandrano of three different crimes, three counts. The first count was assault and battery against another woman whose name was Margaret McGuire, threatening to kill Margaret McGuire. Those were counts 1 and 2. The jury acquitted her of those, found her not guilty. But then there was a third count, the one that interests us here. And let me read to you the exact language from the grand jury indictment. The grand jurors of the state of New Jersey further do present that Marion Palandrano, here's the language, was and yet is a common scold and disturber of the peace of the neighborhood and of all good and quiet people of this state to the common nuisance of the people of this state. She was acting as a common scold. This was using legal buzzwords. They were talking about a crime that judges had developed earlier in history. There was a common law crime called acting like a common scold or being a common scold. In fact, there were New Jersey cases that had applied this crime as recently as 1890. This was an 1870 case. And according to these various cases, as judges tried to describe what is it to be a common scold, here's some language they would use. A common scold is a troublesome and angry woman who, by brawling and wrangling among her neighbors, breaks the public peace, increases discord, and becomes a nuisance to the neighborhood. So that's the crime that the grand jury charged against Marion Palandrano. And how did the court respond to this indictment? Well, they dismissed this third count of the grand jury's indictment. The court said, this crime used to exist in New Jersey, but since then the legislature has come along and has created some related statutes under something called the Disorderly Persons Act. They have covered as much of this old common law territory as they thought should be criminal. They left out the precise conduct that Palandrano was involved in here, just shouting and so forth, involving her neighbors. And so the court said if the legislature didn't include this conduct in the crime when they created it, then it's not a crime anymore. And we, the court, are not going to create it as a crime, or we're not going to sustain it just on our own authority as a crime. There is no common law of crimes. The court also went on to say there may be an equal protection gender discrimination problem here if you've got a crime that is only possible to bring against women, but that's sort of a separate basis for the opinion. So the court ends up saying this is no crime. Similar stuff, but different stuff is covered by the legislature. Now, one exception to the limitation on common law crimes is something called a reception statute. And this is where the legislature in the state, first they go through the whole code and they list all their crimes, and then they say, now if there's something we've forgotten here that used to be a crime at common law, we'll call it a crime under this code as well, and we'll punish it as a misdemeanor, just in case we forgot about it. That is, we receive the common law as a statutory crime. So those reception statutes are a way of keeping the common law definitions of crimes relevant to current criminal law. Now, one example of a reception statute at work comes in Baker versus State, an Arkansas case from 1949, the case of the human puppet master. We've got a farmer who boards lodgers and receives payments from the state's welfare office, but she's shortchanged by the state on a boarder who dies, midway through the month, just before he endorsed his check over to her from the welfare office. And so it happens again later. The next guy dies, and it's only partway through the month, and she says, "Oh ho, this time I'm not going to get stiffed. I'm going to." Ooh, sorry. Anyway, she keeps the guy in bed, moves him around, makes it appear that he's still alive until the check arrives. and then she forges his signature on the check and cashes it, and then says, oh, this guy died. But she got paid in the meantime. And so she's charged with a common law crime, and it's defined, under, say, a Maine 1939 case that says any disposal of a dead body which is contrary to common decency is an offense at common law. The judge told the jury that they could find Baker guilty if she treated or dealt with the dead body of Ed White in such a way as to shock the public decency. The jury found as much. She was convicted, sentenced to pay a $100 fine and $150 court costs. And on appeal, the Arkansas Supreme Court said, yeah, this was a valid use of the common law because the state legislature had passed this reception statute and had declared ahead of time for everybody that the common law crimes that we haven't specifically listed here are nevertheless going to be crimes that can be punished as misdemeanors. So this is an example of a reception statute at work. So to sum up, in the United States, as of the middle of the 20th century and later, the legislature takes the lead in defining what is a crime. That is, there is no common law of crimes. Judges are a little more circumspect in the criminal law area than they would be in torts or in property or in a few other common law dominated areas. And that means that they don't create new crimes to fit the circumstances of new outrages that human beings dream up. The one exception is in areas where there is a reception statute that the legislature has passed and said, no, we're on board with those common law crimes. Fair notice to everybody, those are still crimes here. If you do have a reception statute of that sort, and you have facts that clearly meet the standards of the old common law crime, then you're good to go, consistent with the legality principle. We'll practice with this principle some when we get together next time. See you then.
I rest my head inside